Welcome back to Legalese 123, where we are covering cases across America. Hello, and welcome back to Legalese 123. I am your host, Missy K. I am messing with my microphone. I apologize. I thought I was ready, but I moved it yesterday, and well, here we are. Well, what is going on, everybody? How are we doing? It is Wednesday, the 18th of March. It's hump day. Yay! Well, sad news. We got some more of that S word, snow. I really hope that this is the end of it. Really would like for spring to come. The birdies are around. They're like, hey, what the heck is going on? So, a lot's going on since we are recovering from the Corey Richins trial and everything that has transpired there. Wow, a lot of people are still talking about it, but I mean, we did so much talking about it prior to the trial, then during the trial, and then, there's really not much to talk about after the trial. I keep going like this because it's showing my background, and you don't want to see what's behind the mirror. Don't look behind the mirror. All right, so what do we have going on today? We have Kelsey Fitzsimmons. Now, I have not talked about her at all on my channel because I was just waiting to sort of see how things sort of filtered out with this case. But somebody asked me to cover it. So here we go. Who is Kelsey Fitzsimmons? Well, let's see what I can tell you thus far. She's got a hearing coming up today, and so we are going to see if we can go into that. So let me share with you this. This is Kelsey Fitzsimmons, and if you don't know who Kelsey Fitzsimmons is, she is a North Andover police officer, and well, I went to the next page and it didn't like that. She is a North Andover police. Nope. Sorry. I am having problems this morning. Here we go. All right. Kelsey Fitzsimmons is a North Andover police. Hello, why don't I just add this to the stage? Hello. She is right here. She is a North Andover police officer. She was to be married to Justin Allahan. Justin Allahan is a North Andover fire officer. I don't know what you call it, fire person, fire officer. He's a firefighter. And they were to be married. They have a son together. Believe his name is Caden. Kelsey is 28. I'm not sure how old Justin is. So allegedly, what had transpired was they were to be married. They went to a bachelor and bachelorette party together, with which they had like a mutual party together. Obviously, there was a lot of drinking. And now it's come out that Justin was also doing drugs. And they had a fight. She left the bachelor party and left him there, I guess, and went back to her. It was the bachelor and bachelorette party was in New Hampshire. They're in Massachusetts. She went back to her home in Massachusetts and left him there. 2 days later, and we have a timeline that we're going to go over. 2 days later, something happened, and he ended up getting a order against her to take her son. So the events of that day, she had gone to go do CPR training at somewhere in North Andover, and he apparently was before a judge trying to get this order. He had asked to meet her at a park or something like that. Something happened. She went back to her house. He didn't meet her at the park. When she was at her house, 3 of her fellow police officers showed up at her house. asking that the baby be turned over. There was no CPS or DPS or whatever they have in Massachusetts. And the baby was only 4 months old. She was suffering from postpartum depression. There's some allegations and stuff in reference to that. They then took the baby from her. Justin was there at the house. He was apparently in the basement to take the baby. As she was gathering things for the baby, she was in her bedroom. Again, she's a police officer. She had just received her firearm back. She was out on some sort of leave. We'll go see if we can find out what that meant. And she allegedly had wanted to unalive herself with her gun. And Officer Noonan was in her bedroom with her. A fight ensued, and he ended up shooting her. That's right. Officer Noonan ended up shooting Kelsey Fitzsimmons. So she is being charged with. So this happened on June 30th of 2025. She was shot in the chest by a fellow officer while they were attempting to serve her with a restraining order and an order to take her baby away. And she, Kelsey, was charged with assault of a deadly weapon, but she didn't shoot anybody. So they allege that she pointed her gun at the responding officer, and the officer claims that he shot her in response. So her schedule is to start next week. And so she has a hearing today to go over some more things. So we're going to see if we can get that for you today. Let's go back to, let's remove this, and we're going to bring up a lovely timeline that Emily C put together, which is really, really cute. Emily C is like a kindergarten teacher. She puts things together. So here we have a timeline of what happened to Kelsey Fitzsimmons. So November 2023, Kelsey begins a relationship with Justin Alayan. He moves in with her on March 2024. When we say moves in with her, she has a house. She had a house in North Andover that she purchased herself. So he moves in with her. May 2024, she graduates from the police academy and is sworn in as a North Andover police officer. With Officer Noonan, who shot her, responded to an unaliving and a suicide of a mother and a baby. I kid you not. They both of them responded to this case. On February 2025, Justin and Kelsey have a baby. On Mother's Day, this is alleged to have happened. This is a timeline of their relationship. Justin is drunk and falls in the shower on the 15th, and he smokes weed inside their house, and there's surveillance of that. On June 27th/28th, they get into a fight in Maine. Well, there was in Maine with their bachelor and bachelorette party. Between the 27th and 28th, Justin moves out of the house that they share together in North Andover. On the 30th, Justin is granted an ex parte 209 abuse prevention order and a full custody of the baby. On that same day, 3 North Andover police officers enter her home and serve her with the 209A. And Officer Noonan fires 2 shots at Kelsey in the chest, hitting her in the chest. Kelsey, on June 30th, Kelsey is med-flighted to Mass General Hospital. Justin takes the baby to his home in Stowe. July 3rd, Justin and 3 of his friends are seen on Kelsey's home security camera, breaking into Kelsey's home and taking a whole bunch of property. Apparently, allegedly he took her passport, some gift cards, some cash, a letter that he had written to her that was on her refrigerator, and a whole bunch of other things. On July 4th, Justin's mom texts Lisa, who is a Stowe lieutenant. Justin's mom, Lisa, texts a Stowe Lieutenant Kelly Barheit asking for personal protection. Meanwhile, Kelsey's still in the hospital. On August 7th, Kelsey is arraigned via hospital via Zoom, armed assault with intent to M, and 2 counts of assault with a dangerous weapons. August 28th, Kelsey is granted release after a grand jury only indicted on one of the counts of assault by means of a dangerous weapon. On September 8th, Judge Kathleen McCarthy Nyman finally releases Kelsey from custody with multiple conditions. The multiple conditions were that she needed to live with her parents. She had to do a scram test. A scram test is where they have to breathe into a machine, and Kelsey had injuries to her chest. The whole hearing of this was bananas. And the judge, when they talk about, so have you ever heard of a judge saying there's a hot bench? This was a hot bench. And what is alleged to have happened was that the judge had received some information more than just what the charges were, either from Justin Alain's family or somebody or something, but she had received some more information about Kelsey, made some prejudgments, and then put all of these restrictions on her, and that if she didn't comply, she was going to go back to jail. On September 11th, her attorney, who is Tim Bradle, if you've heard that name before, Tim Bradle is also one of Aidan Carney, aka Turtle Boy's attorneys. So they go before Judge Nyman again on the 12th and orders Kelsey reincarcerated after the defense team files a motion to modify the scram conditions. What that means is that Kelsey was trying to do the scram testing. So she doesn't know when the scram testing is. We heard just the other day that it's 4 days, it can be 4 different times throughout the day that she has to blow into this machine. And because she had the injuries to her chest, it was really hard for her to blow in there. So they had an emergency meeting to see if they could find some other way to comply with the court's order, but not do the scram test. And the judge, hot bench, said, no. And if you can't comply with this order, you're going back to jail. And that's what they did. They threw her back into jail. On September 16th, Justin files a motion to attach the real estate for the payment of child support. So Justin had gone to my mind is blanking, goes to the court to file for, custody of the child. And in that, he wanted, Kelsey was selling her house. She needed to sell her house so that she could pay for legal expenses. And Justin attached the order of the real estate for the child support payment. November, Kelsey sells her home to pay for legal fees and puts $50,000 into account for Justin to use for the baby. On December 23rd, Kelsey is released from a pre-trial detention. Baby C is baptized. Kelsey wasn't there. Kelsey's stepsister was the only family allowed. Lisa asks for more personal protection from the police. Then on the 26th of February, an Essex County DA says no criminal charges after review of Justin's break-in. So remember, Justin allegedly broke into her house. The judge says, or the Commonwealth says, they're not going to file any charges for him. And it is alleged that they're not filing charges because he is one of the witnesses in her criminal case. On March 12th, Judge Jeffrey Karp erased Kelsey's bail conditions. So, she doesn't have in here that Tim Bradle asked for an emergency removal of Judge McCarthy Nyman for a variety of reasons. Let me see if I can get that exact. So in their motion, they said that. So Tim Bradel filed a motion to remove her, and it was on allegations of being biased and judicially improper. Bring up that. All right, here we go. All right, so this is live. This is
Good morning,
Bradel, Kelsey's.
March 18th,
This is
2026.
Judge Karp.
4, Lawrence Superior Court. The Honorable Justice Jeff Karp presiding. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311, scheduled today for a trial readiness conference. Could counsel please identify themselves for the record?
Good morning, Your Honor. James Hoover, Associate on behalf of the Commonwealth.
Good morning.
Good morning, Your Honor. Marina Moretti.
Good morning.
Good morning, Your Honor. Kelsey Bradel on behalf of Kelsey Fitzsimmons.
Good morning, Your Honor. Martha Copley on behalf of Kelsey Fitzsimmons.
Good morning.
This is Kelsey.
Fitzsimmons, and you folks can have a seat.
And if I may, Judge, I have Ms. Healy with me, so she stays at counsel.
Yeah, I'm sorry, her name again?
Ms. Healy, Courtney Healy, our paralegal.
Okay, yeah, that's.
Courtney is his paralegal.
So we're on to, really on to discuss the juror questionnaire, the draft of the juror questionnaire that I emailed you folks on Friday. I did have some preliminary questions. If you don't mind, I think these are fairly quick. So let me just ask about trial readiness. Are both sides ready to begin impanelment on Monday and then start the trial the morning after we get our 14th juror?
Yes. Judge, on that point, I don't want to waste a lot of the court's time. So just a suggestion is, could we do the rest of the housekeeping matters, take a quick break, and then put the questionnaire to the end? Because we may not do it. It may be a moot point.
Okay. I actually, that's one.
They might do a bench trial, and that is why they're doing what they're. So they're getting ready for trial, right? She's being charged with an assault for a deadly weapon, right? And they might do a bench trial, which means that the judge gets to decide what's going to happen instead of a jury trial. So today's hearing is just a status conference hearing of what's going to happen. And so we get to sneaky peek what's going to happen.
On my agenda, because I was going to, let me just skip to that item, right, what you're speaking about. So what I was going to say, mention to you is that I believe at the last hearing you mentioned, Mr. Bradel, the possibility of Ms. Fitzsimmons waiving her right to a jury.
And I'm sorry, this is really, really, really quiet. I can't boost it up anymore. So either you're going to have to listen with headphones or you're going to have to cue it up. And when we're done with this, so I don't blow your eardrums out, I'll kind of give you a countdown of when
trial. Yes. And what I was going to say to you, and we'll give you some time
when the volume is going to change.
We'll take a break and give you some time to talk about it. But what I was going to mention to you is that I really want to, it appears to me that the law, both the statute and the rule, give me some discretion as to whether I would grant the waiver. And the only reason I would, well, let me just tell you my thinking is I would like to do everything possible to avoid having to bring 70-ish jurors in on Monday, if it's going to be a waiver. So what I was going to say to you is I would need a decision by Friday, but it sounds as though maybe you'll want to talk with your client about that even today, so we'll.
Exactly.
We'll pause.
We were gonna have to take like 5 minutes and then.
No, we'll, yeah, when we get to that point, you'll take as much time as you need. All right, couple other quick things. So the trial, we're trying to coordinate having the trial be held in courtroom 2 on the 2nd floor, just to accommodate more audience and media members than we can fit in this courtroom, because as an example, the camera that is set up is actually, I think, either in the jury box or just too close for comfort. So our hope is that the trial will occur, whether it's bench or jury, down in the second courtroom number 2. We are still working on some logistics at our end, and you folks, especially the Commonwealth, may have some logistics that you'll need to go over with Mr. Ruane. If the logistics cannot be overcome, then they can't be overcome. But at least that would be my preference, is to have a bigger courtroom than a larger courtroom than is here. All right, so that's that. And also, I will need, if there's going to be a juror questionnaire, I'm still missing Dr. Zeisel's address, which used to be in Brookline. I'm assuming, is he still in Brookline?
That's another development, Judge. We're actually not going to call Dr. Zeidel.
Okay, all right, but, so would well, we'll get to it later. I'll also need, when and if we get to it, I need an address for Charles DeChara. Is that Commonwealth's witness or the?
No, it's the defense put them on there, but I'm working on that, actually.
You're working on the address?
Yeah.
But it's a defense witness?
It was an independent investigation that was done by the North Andover Police, and they created a report.
Oh.
I wasn't gonna call him, he put him on the witness list, but I think I probably have better quote-unquote connections to get an address, so.
Yeah, just the town or the name of the business, or something sooner than later. All right, so those were the only 2 items that I missed. And by the way, I did take out Ms. Fitzsimmons as being listed as a witness. So you're going to actually see on the next version that in order to save me having to renumber, I just put number 20 intentionally omitted. There's no reason to, and I know why you did it, both sides did it, but there's no reason to put Ms. Fitzsimmons. There's going to be plenty of questions about knowledge about Ms. Fitzsimmons and the case, that her name won't be necessary on there. A couple other questions. One is on the scram device. Is that probation?
Yes.
Oh,
Yes.
hi, how are you?
Good.
Do you mind just stating your name for the record?
Yes, Your Honor, probation officer Tony Kidder.
Okay, and Officer Kidder, well, everyone, let me just think out loud for a moment. I'm concerned, or should I be concerned, that Ms. Fitzsimmons is going to be alerted during the trial to blow into a scram device? Yes.
Yes, Your Honor, I did speak to my supervisor in regards to the scram earlier this morning, and I was going to contact electronic monitoring to make sure that it did not go off during the time that she was in the courthouse.
Okay. All right, I don't know what I don't know, and all I know about the scram device is what the probation officer at the last hearing told me about. So I just want to make sure, I'm sure that you folks are out in front of this, but let's just make sure that it's not visible to jurors, or and that she isn't seen lugging it around or throwing into it in the courthouse. It's still a small courthouse, right? So if probation can do something to shut it off during the court proceedings, that would be great. Actually, better yet, during the time when Ms. Fitzsimmons will be near or in this building, and again, near even coming from parking, I just don't want to take a chance that a juror is going to potential for anyone to see her blowing into the screen.
Yes, Your Honor, I will make sure.
All right.
Okay,
and
I'm gonna
then
pause.
last-
Why? Okay, so hopefully I didn't blow your ear, it turns out. Why is that important? Well, because it could be quite prejudicial, right? Well, look at this criminal. She has to blow into a scram device, right? Why is this thing beeping? Why does she have to do this? It's quite prejudicial, right? Shouldn't be doing that. And I find, wow, this judge is really, I'm really liking this judge.
Last thing is, so I'm already thinking about jury instructions, whether it's jury instructions or whether it's instructions to myself. And so there's two theories of assault, right? Or two ways of assault can be committed. An attempted battery, a threatened battery. Is this one, the other, or both? Or what is
Both.
this? Both. Just that's all I wanted to know whether you did. Okay. So really, I don't have anything else. There is Commonwealth filed a motion. So is that something that you want to do before we break? Does that make sense?
Yeah, the Commonwealth filed a motion to eliminate, on Friday, I believe, or over the weekend, I'm sorry. The Commonwealth filed a motion to eliminate, seeking to admit a number of text messages between the defendant and, her ex-fiance, Mr. O'Layan. Their text messages that we would seek to introduce span the day of the shooting, so just the day of.
I'm sorry, just let me interrupt, all right? So just setting it up for the record, so you're referring to paper 82, which is the Commonwealth's motion to eliminate to admit the defendant's text messages from the day of the assault. I did have some trouble reading them, but then I was given a better copy. But let me just ask, just yes or no, Mr. Bradle, is there an objection to the motion?
There is.
Okay, all right. So now
So
Yes, Your Honor.
That the one thing that I think everyone can agree upon in this case is that the defendant's state of mind on June 30th, 2025 is the most relevant issue before the jury. And what more insight into the defendant's state of mind on the question can we get than her text messages with Mr. O'Layan? I would suggest the Commonwealth is not seeking to admit over the weekend, over a period of time, but literally it is from the morning of June 30th through the afternoon, approximately sometime after 2 o'clock on June 30th. I would suggest that generally they're not particularly prejudicial, but they are relevant because they show that she is angry, upset, at times despondent, and clearly having a conflict with Mr. O'Layan, and this is prior to the service of the restraining order by the North Andover Police.
so your theory is they show what? Anger? What else?
They show her state of mind. And the
No, I
conflict-
know that, but you gave me a laundry list of what the state of mind you say can be gleaned from these.
From a Commonwealth perspective, she's angry at Mr. O'Layan for not, Mr. O'Layan has clearly, is not at the house, has separated from her for a period of time, and she is angry and is trying to get him to come back to the house, and trying to reconcile. So I would suggest that that is consistent with the Commonwealth theory that this shooting happened when the defendant heard Mr. O'Layan.
Shooting happened.
The defendant raising her gun towards Patrick Noonan, and Patrick Noonan, in response, shooting the defendant happened at the time when Mr. O'Layan was in the house.
Okay, so I'm sorry, are you saying that it's the Commonwealth's theory that Miss Fitzsimmons heard Mr. O'Layan in the house and then reacted to it, or?
That's one of the Commonwealth theories, yes. And I think the testimony would be something to the effect of the defendant said, keep him away from me.
Like in this exchange in the bedroom or near the bedroom or whatever?
Yes.
All right. I'm sorry, anything else?
No, I would suggest that it's certainly more probative than prejudicial. If you just look at the text, there's nothing particularly, outrageous in the text, but it does go to show her state of mind.
So, And how would these be admitted? They'd be admitted in this format?
Yes.
Like just, and how are they, how did the Commonwealth obtain these?
The Commonwealth, prepped Mr. Olayan on Friday, and he provided them to the Commonwealth on Friday. So it'll be provided.
All right, again, when I said that they're not putting any charges on him for breaking into the house, he's their star witness, right? Or he is one of the witnesses that needs to testify. So they prepped him on Friday. There's not anything wrong with that. Just saying. No charges on the guy. Let me back up.
The Commonwealth, prepped Mr. Olayan on Friday, and he provided them to the Commonwealth on Friday. So it'll be provided, they'll be authenticated through Mr. Olayan. He would explain that he received them on his phone, and that this is a fair and accurate depiction of the screenshots he took from his phone of the text messages he had that day with the defendant.
And is this all of the text messages that they exchanged on that day, or is this a portion of them?
Just the ones that you cherry
On that
picked.
day, that is all.
She says they're from the entire day.
And the other thing that, if we can just flag it and we'll circle back, is that I provisionally impounded, so I was out on Monday when this was filed, I believe, and I provisionally impounded the motion and the exhibit being text messages because I saw that Mr. Grado had requested it in an email or something, so I just want to, because it's provisional, I want to discuss how we address that. All right, and all right, so let me hear from Mr. Grado.
Thank you.
All right, what does he have to say?
Evidence has to have a rational tendency to prove a proposition in the case for relevancy. And it's not a rational connection to say that because Kelsey was supposedly mad at Justin on this day, that she's going to shoot her colleague from North Andover. It's like if I'm mad at Charlie from Mass Live for reporting, and then I run into the law girls later on, I'm not going to do anything bad to the law girls because I'm mad at Charlie.
You must be the law girl. I am not on social media or any of that. So
Yeah.
don't assume I know who the folks are, but welcome. And you referred to another member of the media?
Yes, this is the law girl. They have their own blog. And it's just a rational thing.
Oh my gosh. Isn't that so sweet? First of all, Mr. Bradle calling them out, which is very lovely. And then the judge acknowledging them. You don't know how many times that like people don't acknowledge bloggers or media people, independent media people, and just like, like, like you're a gnat and you're bothering me. That this judge is super refreshing. I'm really liking this.
This just opens the door to the Justin stuff that is completely irrelevant to whether or not she assaulted Noonan.
Justin stuff.
When it was just the two of them. There's no relevance to it, to this
Right.
charge. And there is prejudice, there is unfair prejudice to show that she's in a fight with her boyfriend. Nobody wants to be judged on that, Proposition A, when Proposition B is completely different, that we're here for trial on. So I just don't see the connection. Her state of mind about Justin is not her state of mind about Noonan. And there's just no possible rational tendency in terms of relevance that because she's mad at some totally different guy, that she's going to hurt her colleague and friend from work.
Well, here's the thing, is perhaps I need to do a analysis under Rule 403, but I mean,
Yep.
It's relevant in the sense that the Commonwealth has to prove intent. It is a general intent, and it's also relevant because I think that Ms. Fitzsimmons has put her state of mind somewhat in at issue because there's information, at least that I've heard, that she wasn't, that if she had the gun, she didn't point it at the officer, she pointed it at herself because of her mental state. So wouldn't this be evidence, again, just not for the truth, but for just to show her her mental state at the time of the incident?
So my strategy on that, and I'm happy to share it, is just that there's enough from the content of the restraining order that without having to open the door to mini trials about who was right between her and Justin, and what are they fighting about, and what's going on, and what are the details of that. She just received a restraining order that said, you know, as I said the other day, I won't go into it again, you know, all the things that order implied were horrible, tragic, and awful. And that prompted her to have a sad, brief moment of intent to self-harm. And thankfully it didn't happen.
Let me say this. I've read these text messages, and I arguably thought that they helped you, frankly, because
Sure.
I know that the Commonwealth sees anger in them. And yeah, I think it could show that. But
I agree.
but they also arguably show it's what they don't discuss, I guess. I'll just leave it at that.
And that's my point, Judge, is that it's opening doors. It's like opening more doors about this when we're not intending on opening that door. And, you know, I don't want to have that thing where, oh, well, this helps us, but then that might hurt us, and then this might help us, and then we're having a mini trial about Justin versus Kelsey.
But Mr. Brado, with all due respect, you folks put Mr. Ayala front and center. Maybe you change your mind about that. It sounds like maybe in the last year and a half you have, which you have a right to do that, obviously. But he's been pretty prominent, and their relationship has been pretty prominent from the defense's perspective, from what I've heard, right, and seen.
So if I can speak to that one, I don't mean to talk about it.
No, go ahead.
Sorry. So Judge, we have to play both sides of that street because the government is pushing that. The government wanted to put, you saw that prior motion limit where they had these 4 things that are like, you know, this is judgment day for Kelsey's entire life. You know, the government wanted to open this case up to Justin and Kelsey and what happened in Maine and all this other stuff, you know, and I think the government's backed off of that, but the government started that fight, and I have to match it. I have to be ready if, out of an abundance of caution, if the government was going to go down that road, I got to be ready. So that's, you know, the Justin stuff has to be vetted, and I have to be ready if he's
Right, you
called
got a
to be
defender.
witness. You know, I have to be ready on both sides. My preference is that we have an economic trial here, where, you know, the issue is Kelsey gets this restraining order full of horrible nightmares. She acts accordingly on it. The government puts their case in, we put our case in, and the fact finder decides. You know?
So, but don't these text messages help your client show that? Because I'm not, again, listen, the Commonwealth, you know your case, both sides. I only know what little I know from the file.
Sure.
But when I read these, yes, maybe there is anger, maybe you could say that, but there's also an absence of any concern for her mental well-being by Mr. A. Allen. Any comments made by Ms. Fitzsimmons that would lead one to believe that she was suffering emotionally at this time, which would, so I guess that's part of the analysis of when I'm doing the 403 analysis is on the prejudice to the defendant. I'm not sure that I see a lot, but I can tell you this is that there is one passage in here that I thought I saw that where he said something about her allegedly hitting him or something, and
It's on the first page, Your Honor, the 4th bubble on the right.
So I give you a proffer on that, and so I appreciate what you're saying, Judge, about on its face, the general gist of those text messages would help in the sense of the distraught mindset. However, if that's where it sits, I can live with that in terms of but we'll talk about the hitting thing. But I'm looking at this like, I feel like the government's gonna try to say that this opens more doors, and I don't wanna go down this road of like, going down, Justin versus Kelsey and everything in Kelsey's past, going back to two other ex-boyfriends. Like, that's where I want to guard against.
Commonwealth said 2 hearings ago, this is a simple case. You said at last hearing, and it will be a simple case, but it's still simple in the sense of what happened in the bedroom.
Right.
And it seems to me that what Mr. Fitzsimmons was thinking at the time is absolutely relevant.
Prosecutor just got up.
Her state of mind and the hours leading up to it would be relevant too. And again, let me say this.
Okay. So what Mr. Bradel is talking about is that, look, what happened in the bedroom happened on June 30th. We want to focus on that. We don't want it to be the Justin and Kelsey show. We don't want to have it be, here's the life of history of Kelsey and her boyfriends 2 years ago. Something that happened 2 years ago is not relevant to what happened that day in that bedroom. And Mr. Bradel is trying to condense it to that time frame and hoping that the government doesn't open it up to be the Justin Kelsey show and their ongoing battle with each other, their domestic fight, which will happen in family court. That's what I was trying to say. Family court.
Making an observation about what I say that they could argue would help the defense or hurt the Commonwealth, but that's only because, again, when I'm weighing the potential prejudice to the defendant and the probative value, that's all I'm really getting at under 403.
So Judge, if I could just invite the court to just focus on that one bubble about the hitting in terms of the 403. And that's really all I'd be concerned about. So there's more to the story, of course.
Something about the hidden.
In Commonwealth, what would you say if that was redacted? So that bubble and just.
I just think the first sentence of that would be fine to redact, but I do think that the second sentence is not about what you need anymore. We need to be the best parents possible, and I cannot do that in the house at this time. I think that's all.
So, Mr. Brady, I don't know if you've heard that. So the Commonwealth is suggesting that. All right. So let me just back up. So my ruling is that the probative value of these, generally speaking, of the proposed exhibit outweighs any, really almost any potential prejudice to the defendant, except that the devil is in the details as to some of the content, and that one of those items being this particular passage where Mr. A. Ellen is alleging that Ms. Fitzsimmons struck him in the face, even though she denies it right there in the response. So the Commonwealth is suggesting we simply just redact the first 2 sentences of the bubble of Mr. Elaine's text about that.
Should that be agreeable to the defense? Thank you.
Okay. And so that would, and the rest that would come in starting with, it is not about what you need anymore?
Yes, sir.
Okay. And if you folks remind me at the time that I can tell the jury that it's common that things are redacted or struck from items just in case it's somehow visible that, in other words, if the jurors can glean that something's been removed, I'm happy at the request of either side to tell them why, which is basically out of the rule that it wasn't missing.
And Judge, also while we're on these, I would waive the request for impoundment.
Okay, waive the request for impoundment.
Correct.
So let's talk about impoundment. What's the Commonwealth? I'm just concerned about jurors just knowing, but
Oh, there must be something juicy in those texts for Bradle to want them to be unimpounded. There must be something good in there that goes to Kelsey. Oh, and now here, see, they're like, no, Judge, it still needs to be impounded. We're worried about the jury. I'm gonna back it up just a little bit, but I think
Talk about impoundment.
Bradle wants us to see it.
I'm just concerned about jurors, just knowing, but I don't know.
Oh, the judge is worried about jurors. Okay, sorry.
I do not see a good faith reason for the Commonwealth to ask for this to be impounded, given the nature of what is in the public already.
Okay, all right, so both sides say it shouldn't be impounded, so I'm gonna vacate the, and I'll do this.
Ooh, we're gonna get to see what the text message is.
I'll vacate
As soon as we have that, we'll let you know.
What I'd like to do is this, Commonwealth, so I have two versions, one's a vertical, and one's a horizontal, is that right? Is that the way to explain it?
Yes,
So
I
the-
think the first version was too small really to be.
Yeah.
So.
So can we just give this back to
Yes,
you,
please.
and then you can shred it, and this will be this, landscape, right? That's landscape, okay.
And that's exhibit one to the whole.
The landscape will be the official exhibit. It will, and it can be docketed in the normal course, public sorry, docketed to the public docket.
Thank you, Judge.
And I'll have to also endorse, I will endorse it that I'm allowing it subject to that revision, so. Just, all right.
Well, we the people already know what it says, so.
Want to take a break for a few moments? Okay, all right, we'll do that. Just, let, Mr. Ruby know. And you folks are-
All rise, please.
Thank you very much.
Always leave it on because you never know what they're gonna say. Hot mic, hot mic. There's Kelsey.
Courses have recess.
All right. So the way they're jostling the camera around. All right. So so a couple of things. So I didn't cover this case right away because I was not exactly sure how things were going to play out. Also, the fact that there is a child involved. I really don't want to do anything that involves children, but that is for family court. But it is so it's kind of like a domestic case turned into a felonious case, I guess you could say, right? So what initially happened was that he had served this well, let's just go back to it. So is they're going to come back to court. So as soon as they come back to court, I will let you know. So let's remove this and let's go back to the timeline that was put together by Emily C. Okay, so Kelsey Fitzsimmons timeline. All right, so on June 30th up here, this is what happened. So Justin was granted an ex parte. That means that without all of the parties being there. So he went in, said these things had happened. Probably this text with the hitting thing probably happened. It's a 209A abuse prevention order. Maybe, she hit him. He said, I'm being abused. But and full custody of the baby. And maybe these text messages, because there was something else there that was stated that about not being able to take care of herself and her baby or whatever. And maybe he used that to get the 209A. And then all she knew was that there was 3 police officers that came to her house. They said, hey, we have this restraining order against you. She reads this restraining order. Obviously, from what Mr. Bradle stated, that the restraining order stated a whole bunch of things that were very upsetting. She's a mother. She's having issues with her boyfriend, and taking care of a baby pretty much by herself because Justin doesn't live there anymore, right? And she's got these 3 people coming to her house. I believe it was in the late evening, and they want to take her baby away. And she's like, what, how, why? And so she's trying to process all of these things, right? And then, like we said, she was in the bedroom with Officer Noonan. She took out her gun. She was going to self-harm herself. And he ended up shooting her. Now, we all know there are many sides to a story. There is Kelsey's side, there's Officer Noonan's side, there's Justin's side, and then there's the truth of the matters in between, right? So, in Kelsey's case, what happened in the bedroom between Kelsey and Officer Noonan are one separate incident versus what happened between Justin and Kelsey and the baby. Although they are kind of related and they are kind of attached to each other. So, what does that mean? So we were going back to, we're kind of stepping back a little bit, waiting for them to come back for this hearing. So when the hearing comes back, I will let you know. So yeah, I can hang on. Trying to do 2 things at once. There we go. Maybe, maybe not. It's not allowing me to. 1 second. It's not allowing me to change my volume. There we go. All right. So as soon as they come back, I will let you know. All right. So we were talking about her first judge, Judge McCarthy Nyman. So Kelsey, this was the first judge that she went to in reference to her charges, etc. And the defense team asked for her to be removed because of allegations of bias and judicial impropriety. So the ex parte communication, the judge allegedly held an undisclosed off-the-record meeting with a probation officer the day before revoking Fitzsimmons' bail. Apparently she had gone in there and talked to him about the scram test, etc., and wanted to make sure that she was compliant, etc. And apparently you can't do that. Defense attorneys accused the judge of conducting her own investigation into Fitzsimmons' compliance with release conditions, which was argued outside her legal authority. It demonstrated the bias. Her lawyer argued that the judge showed a prejudiced demeanor, once making a personal finding that Fitzsimmons was a dangerous person and issuing orders that prevented her from seeing her infant son. So that was one of the other things that she did as well, is that she said, you have a restraining order, you can't go see your son. Should that have been one of her conditions, or is that a family court decision? That was one thing that they argued. The other thing they argued was a procedural irregularity. The defense questioned why the judge, who was assigned to a civil session, inexplicably appeared to handle criminal matters for the specific case without explanation. And so they put it up to the SJC, which is the Superior Judicial Services, and they yeeted her. They yeeted Judge for biased. I don't know if I can get that order. Again, I am behind when it comes to the Kelsey Fitzsimmons case. Let me see if I can find more information on that. we're just waiting for them to come back to court to do the amendment. Plus, we're also waiting for him to release those text messages, right? We want to see those text messages. Oh, my thing's not allowing me to scroll anymore. All right, let's see if we can. I don't know if we'll. Uh-oh. Sorry, I'm just. Trying to look really quickly. So let me share this while we are waiting that. Okay, so let's make this a little bit bigger. Okay, so Kelsey Fitzsimmons, the North Andover police officer who was indicted in Essex County on one count of assault by means of a dangerous weapon. The Commonwealth alleged that during the service of an abuse prevention order, Fitzsimmons deceived officers regarding firearms in her home. They knew she was a police officer. Drew a firearm, pointed at an officer, and pulled the trigger, though the gun did not discharge. They allegedly attempted to chamber a round before being shot by an officer. The Commonwealth presented further evidence of Fitzsimmons' prior alcohol-related violence, mental health struggles, and in 2019 misdemeanor conviction for intoxicated and disruptive behavior. Fitzsimmons relied on medical and psychological evidence suggesting she was suitable for outpatient care and posed no credible risk of harm. Initially, the district judge ordered Fitzsimmons held on dangerous grounds. A superior court judge subsequently found her dangerous, but released her, subject to strict conditions, including house arrest, GPS monitoring, alcohol abstinence monitoring by a scram testing. And when Fitzsimmons claimed that she could not physically comply with the scram testing due to her injuries, the judge vacated the release order and detained her pre-trial. Fitzsimmons moved for reconsideration, proposing urine testing as an alternative, but the judge denied the motion, finding that urine testing would interfere with house arrest requirements. Fitzsimmons then petitioned the single justice of the Superior Judicial Court of Massachusetts for extraordinary relief, arguing the judge erred in refusing less restrictive alternatives and in her conduct. The single justice denied the petition, concluding there was no error or abuse of discretion on the appeal. The Supreme Judicial Court affirmed, holding that neither the hearing judge nor a single justice abused their discretion in ordering detention when Fitzsimmons could not comply with the least restrictive conditions necessary for community safety. The court also found no requirement for the de novo review and rejected Fitzsimmons' arguments under the Americans with Disabilities Act and other statute. The judgment was affirmed. Now, this is when she was asking for the first time to get her bail removed And they went to the SJC saying that because Fitzsimmons was disabled because she was unable to blow into the scram device because of her issues. Oh, dear Lord. Oh, dear. Someone's messing with the mics in the thing, and oh my goodness gracious. Like, I hope if you were listening, thank you. They turned the mic off. They're still out. Okay. So while we're waiting, we'll just go ahead and put this up here. So then on February 10th of 2026, the Chief Justice of the State Superior Courts denied a motion filed by lawyers of North Andover Police Officer Kelsey Fitzsimmons seeking the recusal of Judge Kathy McCarthy Nyman, deeming it moot. In a brief endorsement on the motion, Justice Michael Ritucci wrote, "The judge is scheduled to sit in another session during the period of the remaining pretrial and trial of this case." Uh-oh. The judge is scheduled to sit in another session during the period of the remaining pretrial and trial of this case and was not specially assigned to this matter, as the motion inaccurately assumes. Attorneys Tim Bradel and Martha Cogley, who represent Fitzsimmons, hailed the decision as a victory. This outcome directly addresses the core concern raised in the defense's motion, namely the necessity of preserving the fairness, impartiality, and appearance of justice throughout the remainder of the proceedings. The motion had asked McCarthy Nyman to recuse herself from sitting on the case over several perceived conflicts of interest and accusations of misconduct. Don't know if I can make this bigger. I have to sneeze. Hold on. Sorry about that. Ooh. All right. A reasonable, disinterested observer would conclude that there's a lack of impartiality, or at a bare minimum, oh my gosh, please read, an appearance that the judge's impartiality might reasonably be questioned, and the motion filed by Bradel and Coakley. So, Fitzsimmons is a North Andover police officer, was shot in June by a colleague serving her a restraining order obtained by her fiance. She's accused of pointing a gun at the officer, but said that she had attempted to unalive herself. McCarthy Nyman presided over many Superior Court hearings in the case, beginning with a bail review in August, not long after Fitzsimmons' arraignment in district court. When Fitzsimmons was indicted on a charge of assault with a dangerous weapon, it was McCarthy Nyman who handled her arraignment and subsequent hearings on conditions of her release. That including a hearing in September where McCarthy Nyman sent Fitzsimmons to jail after her attorneys indicated she couldn't comply with the court order alcohol testing. Fitzsimmons was released from jail in December when her lawyers indicated after they lost a series of appeals that she could now comply with the testing. So, let me just look back. They are not back in court just yet. All right. So, I was trying to see if I could get that. I don't know if it's me or if it's YouTube or, well, X is now being terrible, but Google is still working. Maybe I should refresh. Refresh. Let's see. Nope, X is down. That's where I get all my good stuff, right? All right, let's go back here really quickly. Let me just refresh everything because everything is going bonkers. Okay, well, that's not coming up. All right, so let's talk a little bit about Justin Alain. So just recently, Kelsey was shot on June 30th, and then she was in the hospital. She was in the hospital for 53 days. And during this time, as you heard, she couldn't tell her side of the story. She could not say anything because she was incapacitated. And Tim Bradle, who's her attorney, was very cautious about what could come out because obviously there's two sides to the story and there's something in the middle, right? So he was waiting to craft something on her side. So for a very long time, she didn't say anything. And then also the family court issues with her and her baby. She was trying to be very careful about what she said because things in family court really, they can be used against you. So she was holding on to information before she released anything. And perhaps maybe she was trying to play nice with Justin and say, listen, I'm out now. Can we play nice? Can I see the baby? Can things happen? And they're trying to maybe work things behind the scenes. And I don't think Justin was playing nice. And so Kelsey just released things. And the thing that I shared with you earlier, so let's see. So here is the video of him breaking into her house with his buddies. And allegedly, he had contacted the North Andover Police and stated that he was trying to get into her house. And they had allegedly said, well, if you got a key, then we can't help you. You know, we can't hurt you. And it's alleged that he misled them and said that he was living there. But we know that he wasn't because in family court, he stated that he was living with his parents in Stowe, and that is how he has the baby. So here is the video footage of him and his friend breaking into her house. Now, mind you, if he still had belongings in her house, he would have or should have, contacted her family to get into the house. So there you have that. All right, let me see if I can. All right, let's see if they're back from court yet. Hold on just a minute. Okay, they are back from court. I have so many tabs open. Oh my goodness gracious. All right, here we go. All right, here we go. Back in court.
Record on the matter of Commonwealth versus Kelsey Fitzsimmons. All counsel and the defendant are present.
Okay, Mr. Bradel?
Thank you, Your Honor. We filed two things, Judge. We filed a waiver of the right to the jury trial. Attorney Coakley and Ms. Fitzsimmons are prepared to engage in a colloquy with you on that.
Okay.
And then the second thing we did file was a supplemental witness list that I explained to my brother a little bit, some additional names. I would say most of it is probably abundance of caution stuff that probably they won't be called. There's one name on there that did warrant some explanation from counsel for Commonwealth, which I gave them, and I don't expect it to really add much to the trial.
All right, so, let's table that, but I do want to, if the Commonwealth wants to be heard on these additional witnesses, absolutely.
No, I just, if I may put something on the record,
Sure.
as far as the jury waiver goes.
Well, before you do that, I was going to ask, all right, so we have a waiver, I was going to ask whether the Commonwealth takes a position, so.
My only position, while I have no reservations with your ability to be fair and impartial in this case, in an abundance of caution, I wanted to create a record. At some point, I don't think it was last hearing or one of the press conferences that the defense gave outside, a person asked about you, and Attorney Bradel told them and the world, I guess, that you and he worked together in the DA's office some time ago. And so I think there's a perception out there for whatever it is that the defendant had put out there. Like I said, I have no reservations as your ability to be fair and impartial, but I think I needed to create a record about that.
No, that's a very good point, so.
Ooh la la, some tea, some tea. Mr. Bradel worked with Judge Carp. I said crap. Carp. Before Mr. Bradel, were you alluding that you guys have a relationship and that maybe Judge might be more impartial to you? Or Whoa. And I would think that if there was any impropriety, the judge would have said something in the beginning. Anyways, let's see what the judge has to say. I'm going to back up just a smidge.
out there. Like I said, I have no reservations, as your ability to be fair and impartial, but I think I needed to create a record about that.
No, that's a very good point. So, I don't, let me say this, I said before when I was joking with, our media representatives, I don't pay attention to social media, I'm not on social media purposely. I don't read, or listen to or watch or whatever, media accounts of what happens in cases that I preside over or that I potentially could be involved in. So I know nothing about that, but I think it does make sense for me to say a couple things related to that because it strikes me that I did discuss those things with you folks, but I did it at sidebar. All right, so I'll just state for the record that Mr. Bradel and I, so we worked together, well, Mr. Bradel and I were in the same starting class of new assistant DAs in January of '95. Mr. Bradel, I have a picture of all of us, including Mr. Hagan, Judge Hagan, who, like me back then, had a lot more hair. So Mr. Bradel and I were in that class, starting class together. My memory is that I was assigned ultimately after the class. I think we met for a couple of weeks. We were a training class. I was then assigned to Roxbury District Court, and Mr. Bradel to Dorchester District Court. And so that was '95. I left the DA's office in 2001, and at that time I was the chief of the domestic violence unit, which was a superior court unit. So, Mr. Bradel, you can correct me. I don't think that we ever worked together in the sense of worked in the same courthouse, worked on the same trial team. I'm not sure that you and I ever even had a beer together back then.
I agree, Judge. I don't recall one, and, you know, I think that I put you kind of in the same boat as Judge Deacon down in Middlesex, where, you know, we always had a respectful cordiality at work, but, you know, nothing past that. And I appeared in front of Judge Deacon and, you know, never been a problem. And I left the office in '06, Your Honor, so I was there for 5 more years after you. And I haven't seen you in probably over a decade, you know, and I think the comment that Commonwealth Counsel is referring to, I recall as just sort of a generic comment that I thought your rulings were fair and that we appreciated your rulings, that I'd known you a long time, something to that effect.
Yeah, I don't think that Mr. Rubitosi was objecting. You just want to make sure that this trial, I've always strived that all of proceedings, whether it's this case or other cases, that there's a level of transparency. And I think Mr. Rubitosi's point is well taken. So I think I've described on the record what the nature of our relationship was. I'm not, again, I can't say that we weren't friendly, but it seemed like I was maybe you're the crew of people that you more gravitated to were from the Dorchester District Court. I was in the Roxbury District Court. But I'll also say this, is that for complete transparency, I know I had a murder trial years ago with Mr. Rubitosi. I found Archangel Morales, I don't know if you remember that, and I found working against you was you to be a really good prosecutor and really fair, and I respected you. I continue to respect you. That's what I was referring to at sidebar. And you know what? I probably spent I'm
No, I was gonna say, maybe I'm not that memorable because we did 3 burgers.
we did.
Yes.
Who Who else?
I can't remember the names. One was with Ms. Ronan in front of Judge Lowy in Salem.
Oh, wait, all right, so I'm
And
not.
then
I'm
there was
not-
another one here.
Yeah,
I
in
can't
front of
remember
Judge
which one.
Welch.
So now we're going down memory lane and we're now just discussing the good old times of what cases we had against each other. So this judge is so this judge is so refreshing, right? He's like, "Oh yeah, I remember that time. Yeah, yeah. And oh yeah, I remember this. And we shared a beer. And oh yeah." Well, they doesn't have a Boston accent. And that's not a Boston accent. But anyways, wow. Mr. Gubatosi and you now still have history.
You know, I wasn't counting the ones where you were second seating you were like second seating a more junior attorney, but I do remember one in which the two of you prosecutors beat me up pretty good. It was here in this courtroom. I had made a mistake and opened the door to something, and it was Mr. Gubatosi's fault, because all of a sudden that sidebar, you hadn't said two words during the trial, but raised the issue. But in any event, listen, I respect both of you folks. I said on the record, I don't know Ms. Coakley. I don't believe professionally. I think that you may have been the chief of a unit in Middlesex at the same time that I was the chief of the domestic violence unit. I think we may have traveled in the same circles, though that would have been decades ago. But I don't think that you ever appeared before me. I don't think we ever had cases against each other. Again, I respect you as much as I know you, and in any event, I think that that's full disclosure. I'll also just say, as for Dr. Zeisel, you said Dr. Zeisel is not going to be
Correct.
Okay. So, because I think I already mentioned it, he was someone that I used often when I was in practice. So, but it's been years since I've seen him. All right. So, is that sufficient? Did I address? Okay. All right. And the bottom line is, I am confident that I can be fair and impartial.
We do too.
I would not accept the waiver, frankly, if I thought that there was some risk that some favoritism would potentially come into play, or if I thought that I couldn't divorce myself from information that may not be admitted at the trial. Okay, so I'm very good at compartmentalizing. I will only consider evidence that's admitted at the trial. All right, and then we'll talk about mechanics and all that afterwards. Let's go through the colloquy. I'd like to, before we have the colloquy, can I see
Colloquy.
Fitzsimmons at sidebar for a moment?
Colloquy and Miss Fitzsimmons at sidebar. I love that he invites. Oh gosh. Oh gosh, I'm so sorry. Cover your ears. Cover your ears. Oh my goodness. Sidebar. I love that he invites her up there too. I think that's great. Oh, we got the spinny wheel of death. Hopefully it goes away. All right. So now we caught up in real time. So, as you go through cases, you see each judge, right? And as you're watching the lawyers give their doing their jobs, and we do judge them. You judge the judge. How is the judge doing their job, etc. But just remember that all of these things that we're going through, and we're learning, it's a learning process, right? Even the law tube lawyers, they're learning things as well. Lawyer, he always talks about how he's learning something new. He doesn't know all of the laws in all of the states and everything, and so he's learning something new. And there's always room for improvement, right? There's always time to learn, etc. So with that being said, we talk about judges and how they rule their courtrooms, etc. Now, Judge Beverly Canoni, she had some very hard and fast rules in her situation. And we didn't like some of them because they were very, very seemed slighted or slanted or biased, if you want to say, towards the prosecution and against Karen Reed. And we felt that Karen Reed was getting side railed, right? Because of all of the issues that were coming into play, and that everything was like every day there was something new. And you're just like, how is this possible? How is this possible as a person who's being accused of this crime, and the way that things were handled, how these things are coming into evidence, or that they're not getting evidence, but it's still coming in, and just a whole bunch of shenanigans and stuff. And you're like, how is this possible in 2024, 2025? How are these things still happening? And could it just be Massachusetts? Well, I don't think that's the case, because if you look at the Corey Richins case, right? Some of the things that came in, you're like, how is that possible that came in? And Judge Mrazek, he was the most even-keeled person, right? And the defense kept pushing him and saying, this shouldn't be in, this shouldn't be in. And he would give the ruling and the law as to why things should come in. And that is just the way that it was handled. So make sure we're still waiting. So it just goes to show you several different things, right? Number one, be careful what you write in text messages, etc. As you see here in this trial, these text messages are coming in. The judge ruled it's not more prejudiced than probative, right? And now he's going to be the person who gets to judge the case because they waived the jury. So what does that mean? Don't write anything important in your text messages. Your Google searches. Don't be Googling stupid things that might incriminate you. Don't be writing in a journal about a timeline that doesn't coincide with the timeline that actually happened, because that could be used against you. You know, there's just all of these what not to do. Don't crime, people. Do not crime. So one of the things that I was going to try to pull up for you when I was talking about Kelsey Fitzsimmons and holding her cards very close to her was that just this earlier, last week, I believe it was last week. Oh gosh, it's been at one point in time, Kelsey had cameras around her house, and she or somebody released these videos of Justin Alain smoking. We don't know what he's smoking. It's alleged that he is smoking THC, weed, vaping. I'm not exactly sure. It's alleged. And a lot of people were questioning, oh my goodness, if he is smoking this, he's supposed to be an Andover firefighter, and is he supposed to be smoking anything? And so this just happened 4 days ago, that it says here the North Andover firefighter Justin Alain was placed on administrative leave by the department on Friday, pending the outcome of an investigation, according to Fire Chief John Weir. And that was just after Kelsey had went ahead and released, or somebody from Kelsey's camp released the video of him smoking. Because allegedly, you're not allowed to do that. Allegedly. So we are just waiting for them to come back to court, and hopefully that will be soon. So welcome back to Legalese 1, 2, 3, where we are covering cases across America. All right. So while we are waiting for that, I had paused and came back, and now when it's like restarted. While we're doing that, we're going to bring this up, and to be fair and impartial, Justin Alayan was on Boston 10.
Exclusive tonight, as we are hearing from the former fiance of Kelsey Fitzsimmons, the North Andover police officer who was shot by a fellow officer. Fitzsimmons contends her fiance broke into her house days later to steal evidence in their ongoing child custody case. NBC 10's Robert Goulston brings us the exclusive one-on-one.
Kelsey Fitzsimmons' estranged fiance, Justin Alayan, sat down with NBC 10 Boston to share his side of the story. He did not want the interview recorded. He admits this is him with 3 others, forcing the door open to the home where he lived with Fitzsimmons until they're falling out. Alayan and his attorney shared documents they say prove he still lived there, and he told us, "I had every legal right to get into my own home, to get my belongings, and more importantly, my son's belongings."
He has no rights to that house whatsoever.
Fitzsimmons' attorney Tim Bradle says when Alayan requested the restraining orders days earlier, he signed an affidavit that said he no longer lived there and lied to the officer when he asked for an escort.
He says that he still lives there. Completely contradicts what he already swore to the probate court judge, family court judge, to get the restraining order.
Bradle argued Alayan is not being charged because the DA needs him to testify against Fitzsimmons in the criminal case. He is on the witness list for Fitzsimmons' criminal case, but not a key witness.
He might be a background witness. He heard the shots, but as far as what happened in the bedroom, he has no idea.
Alayan told us he did not touch any of Fitzsimmons' stuff on the day in question, and he said he even called police when the alarm went off. He also told her father that day, "I tried to do everything to help your daughter." Fitzsimmons' criminal case will be back in court on Thursday with a trial scheduled to start on March 23rd. In Lexington, Robert Goulston, NBC 10 Boston.
And be sure.
Okay, so for full transparency, that was his side of the story. Again, there's one side, another side, and then something in between, right? You just never know. All right, let's see if they are back in court. They're saying things, but they're not on the record again. Here we go. Oh, no, we're still on the the noisy machine, we call it. Okay, so we're going to bring this up. And so this is Kelsey. Oh, I didn't know that her baby was premature. Justin was smoking here. This is outside of her property. You get the point. He's smoking. Actually, that looks like a pipe to me, so I don't know what you smoke from there, but you can see him smoking. He was then sent. Um, he was then sent unpaid administrative leave. All right, we're back in court. I'm gonna put this up here, and I'm gonna back it up just a smidgy smudge. Oh no, I didn't want to do that. Kelsey is being sworn in.
Why don't you focus?
Okay, here we go. He's talking. We can't hear him.
Colloquy of the waiver.
Okay.
Yes, she is.
All right, why don't you folks?
Gonna
why don't you
colloquy.
take the witness stand, and you can pull a chair over for you, Ms. Attorney Coakley, if you'd like.
I can stand.
Please.
Ms. Fitzsimmons, could you raise your right hand? Do you solemnly swear to make true answers to such questions put by the court or upon its directions that will be done?
Okay, good afternoon, you can have a seat.
Good afternoon, Your Honor.
You can put yourself right up to that mic. So as you know, I'm Jeff Karp, and I'm a judge here at the Superior Court. And I understand that you'd like to give up your right to have a jury decide whether you're guilty or not guilty of the charge. I need to just ask you some questions to make sure that you understand the right that you're giving up and that you're doing it voluntarily, okay? And that you know what the consequences are. Now, so I'm gonna have a lot of questions for you. If at any time you don't understand something that I say to you, it's perfectly fine to interrupt me and tell me I don't understand. If at any time you'd like to take a break and speak with Attorney Coakley, we can give you that opportunity. We're in no rush here. It's very important that you understand all that I tell you, yeah, okay? All right, so first thing I'd like to do is, where's the indictment, Mr. Boyne? Can I grab that? So you understand that you're charged in a single indictment with the crime of assault by means of a dangerous weapon. Do you understand that?
Yes, Your Honor.
Okay. And do you understand that, have you discussed with your attorneys what the Commonwealth needs to prove at the trial for that charge?
Yes, Your Honor.
Okay, and do you feel as though you understand what they've told you about that?
Yes, Your Honor.
And do you understand that that charge, assault by means of a dangerous weapon, carries up to 5 years in state prison if you're convicted?
Yes.
Okay. Attorney Coakley, either you or Attorney Bradle have gone over the elements of the charge with Ms. Fitzsimmons?
Yes, Your Honor, we have.
Okay. All right, so I need to just ask you some background questions to get some background information. Some of this I already know, but I still need to, I need to ask you formally.
Needs to put it on the record.
State your full name.
Kelsey Erin Fitzsimmons.
And how old are you?
I'm 29.
What is just your month and year of birth?
11/18, November 18.
All right. And where were you born?
Concord, Mass.
How far did you go in school?
I got my bachelor's degree and I went to half of law school.
Okay. You went to what?
Half. I did
Half of
half.
law school? That's enough. Was that enough for you?
No, I'm gonna go back.
It's gonna go back.
Going back.
Okay, yeah.
And you said you got a bachelor's degree in what?
In criminal justice.
Criminal justice, and where from?
Where am I from?
No, where did you get the
Oh, I'm
bachelor's
sorry.
degree?
I'm nervous. I'm sorry. Fisher College in Boston.
Okay, all right, and totally understandable that you're nervous. All right, and again, some of this I know, but I have to ask, what are you? You can't be presently working, right? You're not working now.
No, you're
Right. And your last job was with?
patrol officer with the North Andover Police Department.
Okay, and how long were you there, roughly?
About a year and a half, if you count the academy.
Okay. So you went to the police academy and
Yes.
then, okay. What else? And just normal job duties as a patrol officer in North Andover.
Respond to 911 calls, emergencies, medical emergencies, calls for service in the town.
Okay. All right. And did you take any prescription medications, over-the-counter medications, or drugs in the last 24 hours?
Yes, I have.
Okay. And what have you taken in the last 24 hours?
In the last 24 hours, I've taken fluoxetine,
Okay.
hydroxine,
Okay.
and lorazepam.
All right. And do any of those medications, or have any of those medications affected your ability to understand the proceedings today here?
No, Your Honor.
All right. Did you consume any alcohol in the last 24 hours?
No, Your Honor.
And have you ever been treated for any mental health condition?
Yeah.
Okay.
Yes.
Do you feel as though that you're suffering from any mental health condition today? In other words, that like right now as we're going through this, that you're feeling some effect of any mental health condition?
No.
And do you feel as though your mind is clear today?
Yes, Your Honor.
And have you understood all that I've discussed in open court with the attorneys about, up to this point, about even like the motion to admit the text messages? Have you understood all of that?
Yes, Your Honor.
Okay. So I'm just going to go over your constitutional rights. So you have a constitutional right to one trial of the charge. And you have the right to choose whether to have a trial before a jury or a judge. At a jury trial, the jury decides whether you are guilty or not guilty of the charge. And the judge's job during a jury trial is to rule on legal issues that arise during the trial, to instruct the jury on the law of the case, in other words, what the Commonwealth has to prove, and to impose a sentence if the jury were to find you guilty. So that would be the judge's job during a jury trial. But the jury would decide whether or not the Commonwealth proved that you were or are guilty beyond a reasonable doubt. All right? You understand that?
Yes, Your Honor.
And at a jury trial, you have the right to a trial here with 12 jurors. These are people selected from the community. You'd have the right to participate in selecting the jurors. And you could not be found guilty at the jury trial unless the Commonwealth convinces all 12 of those jurors that you are guilty beyond a reasonable doubt. So do you understand all of your rights and how a jury trial works?
Yes, Your Honor.
And also, you could choose to have a trial by a judge instead of a jury. And in such case, the judge cannot find you guilty unless the Commonwealth convinces the judge that you are guilty of the charge beyond a reasonable doubt. Do you understand your right to a judge trial?
Yes, Your Honor.
Do you understand that by waiving your right to a jury trial, the judge will be me? I will be deciding whether the Commonwealth has proven the charges. Do you understand that?
Yes, Your Honor.
Okay. And do you understand that by waiving or giving up your right to a trial by a jury, that I just already told you that. So do you generally understand the difference between a judge trial and a jury trial?
I do.
Okay. And do you have any questions at all about the difference between those two types of trial?
I do not.
Now, I'll just hand you this. And I'm showing you a form called a defendant's waiver of jury trial and consent to trial by a judge. Did you read that form?
I did.
Did you discuss it with counsel or the attorneys?
I did.
All right. And did you sign that form?
I did sign it.
And do you understand that the form says in writing what you and I have been talking about thus far about giving up your constitutional right to a trial by a jury?
Yes.
Okay, did you sign that form voluntarily?
Yes, I did.
And by signing the form, are you saying in writing that you know about and understand your right to a jury trial, which is explained on the form, and that you voluntarily give up that right.
Yes.
And do you now willingly and voluntarily waive your right to have a jury decide your case instead to choose? You think that I have never done this before. Maybe I'm the one that's nervous.
I'm nervous,
Let me
so.
start over again. Do you now willingly and voluntarily waive your right to have a jury decide your case and instead choose to have a judge, that being me, decide if you're guilty or not?
Yes.
Okay. And do you understand that your waiver of your right to have a jury decide your case is final, and you cannot change your mind and ever ask for a jury trial again in this matter? Do you understand that?
Yes.
Has anyone threatened you or forced you in any way to waive your right to a jury trial?
No.
Has anyone promised you anything in return for your decision to waive your right to have a jury decide the case?
No.
Have you had enough time to fully discuss your right to a jury trial and the difference between a jury trial and a judge trial with your attorneys?
Yes.
Do you feel as though your attorneys have acted in your best interest and that they have fully and adequately explained your right to a jury trial and the difference between the two types of trials?
Yes, Your Honor.
Have you been confused by anything I've said thus far during this colloquy?
No.
So as I understand it, then you're waiving your right to have a jury decide your case, and you're choosing to have me, a judge, decide whether or not you're guilty because you want to and because you believe it's in your best interest to do so. Is that correct?
Yes, Your Honor.
All right. And the defense, any additional questions that you guys should pose? Commonwealth?
No, thank you.
None? Okay. All right. Does the defense or the Commonwealth know of any reason I should not accept the waiver?
No.
No, Your Honor. Okay. All right. You may step down. Thank you very much.
Thank you, Your Honor.
All right. I'm going to make the following findings. Yeah, no, Mr. Royan can take that. Thank you. So I'll make the following findings. I find that the defendant, while she is presently or has taken medication, prescription medication in the last 24 hours, I find that that medication has not affected her ability to understand and participate fully today. I also find that although the defendant, Ms. Fitzsimmons, has reported that, or at least I don't know if she reported it, but I do know that at least in the past, she suffered from mental health conditions, and that perhaps some of that medication is related to that. I do find that any mental health condition that Ms. Fitzsimmons may have had or has not affected her ability to understand and participate fully in the proceedings here today. I further find that Ms. Fitzsimmons understands the nature of the charge against her and the consequences of waiving her right to a jury trial. I find that the decision to, strike that, I find that Ms. Fitzsimmons' decision to waive her right to a jury trial is made with the advice of competent counsel. And finally, I find that the defendant's waiver of her right to a jury trial has been made knowingly, willingly, intelligently, and voluntarily, and with the full knowledge and understanding of its consequences, and accordingly, I accept Ms. Fitzsimmons' waiver of her right to a jury trial. All right, with that in mind, so we'll, anything you folks want to go over, but I anticipate we'll just start on Monday morning. Are you prepared to? Because maybe you're not, given that I had said that.
Sure, I hope to be. I mean, that wasn't the plan for all our witnesses, but we'll reach out today and make sure,
Okay.
or ensure everybody that we can have this available Monday.
Okay. All right. And so let me say this. I realize that from both sides' perspective that, trying a case, whether it's jury or not, is like trying to, it's difficult herding all your witnesses together. I usually try to make a joke about it. It's like herding fish or something, but Mr. Kubitosi's heard that probably 300 times. But in all seriousness, we will, Mr. Rowan, we're gonna go full days. And to the extent that you folks, you run out of witnesses on a day, that's just life, that's fine. Do you expect now with this new, let me ask, with the new kind of schedule where the trial is, the actual evidence in trial is gonna start earlier, do you expect any witness availability issues?
Well, everybody was free for the week, so no, I mean, I don't anticipate whether somebody is available Monday in particular.
Okay.
We'll find out.
All right. So it is my anticipation that whatever the, however we proceed, that the trial will be over by Friday. Is that a good, fair schedule or fair belief that I hold, I guess?
Yes, so.
Okay. Okay, so we'll just start up on Monday morning, all right? I will see you folks at.
I'm sorry, I just wanted to point up something for you that you were talking earlier about jury instructions and instructions that you would take into account yourself. And there's one slight, maybe a curveball. There's a code of Massachusetts regulations. Okay. I just want to give you the citation. It's 555 CMR 6.05 parentheses 3 close parentheses.
All right, so let me say this. I don't know exactly what you're referring to, but maybe it makes sense for me to just explain. So what I will ask is that you folks submit, they can be in the form of jury instructions, but just, instructions that I will use when I deliver as to the law of assault by means of a dangerous weapon. So whatever it is that you're referring to, Mr. Brady, you should just put in that document again, whether it's however you want to title it, that's fine, but.
It's from the post-commission regulations, Judge, and it's a CMR that states that an officer is not permitted to use deadly force to someone who is a danger only to themselves. And that's really the central issue of the case.
Right, but again, without having it in front of me, what does that have to do with whether the Commonwealth will be able to prove that the allegation is that Ms. Fitzsimmons committed the assault by means of a dangerous weapon. So I'm not following.
I think it has sort of a general import where if the court has a reasonable doubt as to whether or not Ms. Fitzsimmons was engaging in conduct that was harmful only to herself, it does not, by law, excuse the Officer Noonan shooting her.
Frankly, I
don't
understand, but
I'll spell it out.
So let me just hold on one second, Mr. Brady. What I expect is that perhaps at the end of the evidence and even before closings, we'll have a charge conference. We'll treat it just like we would in a jury trial, and you folks can make your pitch on the law. But I will want some submissions on the law that I should be. Again, as it relates to the charge and the elements and things of that nature, if there's some defense that you're asserting related to that, you can, perhaps that would be a mechanism.
Put it in your papers.
All right, but right now, I don't understand it, and I'm not sure that I need to at this point. All right, and anything else?
Your Honor, do you start at 9 a.m.?
Yes, I'd like to. We do our best to start at 9. Mr. Wayne and I are always ready, but.
I know Mr. Wayne is up early.
But Mr. Wayne and I are, seem to be the only ones that are ready at 9. But, yeah.
And just folks, 9 to 4 is a full day for the court. I'm just,
Right.
okay, thank you.
It is. And like I say, if you folks can disclose to one another what witnesses you think you're going to be calling on a given day, and that would be.
And with your permission, I think we should be able to pre-mark a number of exhibits.
Okay. So you'll work that out with Mr. Wayne. That would be great. Also, if we need to take a defense witness out of order, I certainly would hear the Commonwealth if there's an opposition to that. But even for a jury trial, I typically would allow that. Again, if it's a scheduling related matter, not a strategy decision, but if there's some scheduling conflict, that will help to proceed. All right, so we will see you folks Monday morning. Thank you.
Thank you, Your Honor.
All rise, please.
All right. Yay. Wow. Okay. So what are we talking about here? As you saw, her charges are still great, right? It's a 5-year sentence. Obviously, he could, if she gets convicted, he could lower that or whatever the circumstances are if he wanted to. He's the judge, right? So it's up to a 5-year. I don't know if it's a mandatory. I don't think he heard him say mandatory. I think he said up to 5. Anyways, you correct me if I'm wrong. So this is going to happen on Monday. As you heard the prosecution, he said, hey, I've got these witnesses and they're supposed to be available all week. And so here we go. And we know that Justin's available, right? Because Justin's on paid administration leave. So he's available. Kelsey's available as well because she's not working either. But remember, she does not have to take the stand in her own defense, right? So that is what is going on. So we are going to go ahead and stop this for the moment. And if you have any suggestions about Kelsey Fitzsimmons, let me know. I'm probably going to see if I can do like a deeper dive into things and put some things together a little bit more polished, like I always do. Today was just, she had a hearing and let's just hop on in. Let's just jump right in. So very exciting, going to be a bench trial, and it's a dangerous weapons charge, right? It's dangerous to, weapons charge against her fellow officer. And we'll finally get to hear what happened, because remember, there's her side, there's Officer Noonan's side, and there's something in the middle. So thanks for joining me. Hope you have a great one. Thanks for watching Legalese 1, 2, 3. If you like what you saw, please like and subscribe for more content.